think we'll go ahead and get started, just to keep everybody on track for the presentations. I'd like to welcome everybody. Thank you. My name is Justin Nestor. I'm on the board for the iWiki Northwest chapter. It's my pleasure to introduce two speakers today who are seasoned practitioners, workers' comp practitioners in the Northwest Indiana area. The first is Ed Lawhead, plaintiff's lawyer from Schreiner, Malloy, and Etzler. Graduate of Loyola University in Chicago. No, that's not you. Purdue University, 1997. Valpo University School of Law, 2006. Member of the Lake County Bar Association, American Bar Association, Indiana State Bar Association. And then to my right is Joe Porto, staff attorney with Travelers Insurance at their office in Maryville. 1972 graduate of Loyola University and a 1976 graduate of John Marshall. Joe and Ed both have substantial experience and are great guys that I know. They're going to talk to you today about issues surrounding undocumented workers for Indiana workers' comp claimants. So with that, I turn it over to them. Thank you.
Do we have a timekeeper?
Put the pressure on us already.
People on schedule.
Good morning, everyone. My name is Ed Lawhead. That's my real name, and I'm attorney. It's not my stage name or anything like that. My firm, small firm, 3 attorneys. We practice in Highland, Indiana. Mainly do workers' compensation, personal injury. I do Social Security disability work, as does Sandy here. A couple of familiar faces, Doug, Tony. Been practicing about 4.5 years. Enjoy the plaintiff side of work. Joe might have a counter to that. On the defense side, he and I frequently have cases together, but we have a good working relationship. Joe.
I was licensed in Illinois in 1976, so I come from 2 backgrounds, the liberal state of Illinois and the conservative state of Indiana. I came to Indiana in 2001, started cases there, and then our office actually moved to Indiana in 2006. I started in private practice, so I handled some civil cases, tried some jury cases, tried some criminal cases, tried some workers' comp cases, but ultimately ended up handling solely defense workers' comp. I don't know the background of everybody, but Doug Maher's back there. He was a former hearing member of the Indiana board. Sandy's here. She's a plaintiff's attorney. Give her the blessing. Tony's here. He worked for the board. Now he's with Randy Klesmer down in Indianapolis. I don't know the other people. I thought I'd just give a little preface as to workers' comp and how we got here. I don't know if everyone understands the genesis of workers' comp, but there was what I consider one of the greatest presidents was Teddy Roosevelt. In 1908, he was elected. That's the last year that the Cubs won the pennant, by the way, 1908, the World Series. He came into office and he started what was called social legislation, which meant there were child labor laws that came into place, work days, and one of the things that came out of this was workers' compensation law, which actually existed for now about 100 years. Some states are celebrating the 100-year anniversary. And if anyone's involved in claims, they know that there's 3 basic rights that an employee has. That's a right to lost time, temporary total disability benefits, medical, and permanent partial impairment, if any. The years passed by, and the subject of illegals, unauthorized, wasn't even a thought in regard to workers' comp. When I started in '76, this didn't even come up. But as we watch the presidential elections, we see that illegal immigration is a hot-button issue. And that basically started about 30 years or so. And in 1986, under Ronald Reagan, they had the Immigration Reform and Control Act, which Ed will discuss a little with you now.
Now, the Pew Hispanic Center, they estimate anywhere between 8 to 12 million illegal immigrants in the country, comprises about 5% of the workforce. Now, there's an influx of undocumented workers in the late 70s, early 80s, and the federal government wanted to do something about that. Joe, one of his favorite presidents is Ronald Reagan. This Federal Immigration Reform and Control Act was enacted in 1986. It was specifically enacted to deter employers from hiring undocumented workers, primarily from Mexico and the southern countries below the United States. There was this employment magnet drawing illegal immigrants to our country because of our relatively stable job market. Joe will say thanks to President Reagan, and the relatively high wages that you can earn in this state. Again, the broad, simple purpose of this federal legislation was to prohibit the employment of illegal aliens in this country. Now, I won't bore you with all the statutory language and whatnot. That's the United States Code up there. But most importantly, it made it unlawful for an employer to employ an unauthorized alien, whether that be hire, recruit, or even refer someone to another contractor, say for a roofing job or drywall job. It made it unlawful to refer any illegal alien for a fee.
And there were criminal sanctions that were attached to this.
Right. Now again, made it unlawful to hire for employment in the U.S. an individual without complying with the requirements of subsection B. This is meaning background checks, which we'll discuss a little bit later. The employers were now obligated to verify the undocumented workers' backgrounds via social security numbers, passports, driver's license, and whatnot. And if you continue to employ an unauthorized, undocumented worker after gaining knowledge of their illegal status, this was also unlawful and a violation of IRCA, IRCA. Again, and under IRCA, the employer is legally obligated to terminate the undocumented worker immediately upon gaining knowledge that he or she has become an illegal alien. And IRCA does protect the employer from the illegal alien bringing discriminatory action or wrongful termination claim. Well, Joe, you maybe talk a little bit I-9 there.
The government requires employers and employees to fill out what's called an I-9, and it's in the packet there. Basically, the employee certifies that he's legal, that he's okay to work. The employer certifies that he checked out the documentation that makes the person legal to work. There are numerous documents that the person can bring. They're all listed in the handout. There's maybe 20 different documents.
Now, both Joe and I have encountered anecdotal stories about Social Security numbers passing or crisscrossing across the country. Comes up in New York, comes up in Michigan, comes up in Arizona. I mean, more states than I've even traveled to in my life. I believe Joe encountered one where the Social Security number came up 9 times, I believe.
Right, 9 different states had a hit. If you're in the claims business, I don't know how it's done, but these Social Security numbers are run, and they'll get hits. And like I say, one case I had came up with 9 different hits in Michigan, California, New York, across the United States.
And this employee verification system, that's the keystone of the IRCA. It obligates the employer to have some due diligence and check the background of these illegal workers before hiring them. And the employer's records can be audited from time to time. There's the U.S. Immigration, Customs, and Enforcement Division of the federal government, and they'll give the employer approximately 3 business days to get all their documents in order and prove that their employees are legal citizens of this country and are authorized to work in the country. And then down here, again, is important that IRCA imposes civil monetary penalties. That can range from as little as $375 up to $16,000 per violation. Depends on the severity. There's other factors that go into it. But most importantly, if it's egregious behavior by the employer, fully knowing that the employee is an illegal, unauthorized worker, yet continues to employ them, hoping to get by with it, then it's up to the, they call it ICE,